reserve 5 minutes of my time for rebuttal. This is a first-degree murder case. Before I get into the details, I would like to frame my discussion with a couple of legal principles. I do this advisedly because I think the court is probably going to think you're saying the very obvious things, but there is a little nuance that I hope sort of informs exactly what I'm arguing and how I'm viewing the case. The first of those legal principles is the basic sufficiency standard from Jackson versus Virginia on to the present. And the nuance that I want to emphasize to the court, and again, I'm not pretending this is something the court doesn't know, but that standard requires that the evidence be sufficient that a rational trier of fact could have found all of the elements to be proven, and also that a rational trier of fact could find all the elements to have been proven beyond a reasonable doubt. And it's that beyond a reasonable doubt part that I would like to emphasize today. The second legal principle has to do with first-degree murder. And it is my position that in one way that is relevant to this case, first-degree murder is actually quite hard to prove. First-degree murder, as the court knows, requires premeditation, meaning an act done after the exercise of reflection and judgment. And the statute goes on to say that the jury must consider whether the accused was sufficiently free from excitement and passion as to be capable to premeditation. The reason I say that that's hard to prove in certain cases is because it is placing a burden on the state to prove, to prove a negative. The state is not just proving something affirmatively, they're disproving the possibility that the defendant was impaired by excitement and passion. And that can be, I think that can be hard, particularly in a case, as I'll get to, like this case, where there is some kind of hole or gap in the middle of the case. When I think you combine those two principles that I've set out, what the state had to prove here, there's no dispute really at trial, certainly no dispute here that Mr. England shot Ms. Polk in the back of the head, and there's no dispute that was the kind of shot indicating that it was not an accident, was not self-defense. That was a shot fired with the expectation that she was going to die. So we're not disputing that. But what the essence of the defense at trial and the argument on appeal is when you look at sufficiency review and when you look at the definition of premeditation, the state had to prove that he was not so angry at the time he pulled that gun that he couldn't reflect or exercise judgment. And the state had to prove that he wasn't in that state beyond a reasonable doubt. So they had to prove that negative and prove it beyond a reasonable doubt.
So one of the ways, it being a hard thing to prove, but one of the factors I believe is calmness after the killing, right?
That's correct.
Okay. So I guess the reason for that would be if someone were under the throes of a passionate episode, that excitement would remain for a while afterward. And so in this case, was there evidence that the defendant was calm after the killing and perhaps had lied or, I know the issue with covering up, but acted calmly afterward? Will you admit that?
So I guess I'd say two things. One, I think in my mind, the issue of calmness is irrelevant, at least in terms of being free from excitement and passion, is if a defendant has exercised judgment, has made a reflection, cool reflection, that I want to kill this person, and they kill that person, then logically they're going to be calm afterwards because they have done what it is they decided with exercise of judgment they wanted to happen. I'm not sure that's that different than the way you phrased it, but that's how I think about it. I think the evidence as to what happened afterwards, whether that constitutes being calm, I do not concede it establishes calmness in the sense that...
Could a reasonable jury, though, find that it did?
I don't think so. I mean, the
It
proof...
would be wholly unreasonable for the jury to draw that inference?
I think what the jury could have known was that the time frame is not exact, but Mr. Hoover returns to pick up Mr. England. Mr. England comes out, he gets in the car, he has a beer, and according to Mr. Hoover, has the gun case. Mr. Hoover testifies that he does not immediately sort of notice anything is wrong, that Mr. England is not crying or shaking. And then Mr. Hoover testifies as they drive, Mr. England is upset, so upset that he stops to figure out what's wrong with him. And they have this discussion, and Mr. England is crying at various points. So I think there is a jump between someone is not crying and shaking and someone is calm.
Tell me, I don't recall, when did it occur that he asked his friend to stop at the river so he could pray?
I don't know that the time is exact. I think there was this store, Party City, that they kept sort of going by, which was 20 or 30 minutes away from the house. I think the time that there is evidence that Mr. England is crying, maybe trying to contact his wife, is at the Party City, so maybe 20, 30 minutes after leaving the house. I think the discussion of stopping to pray or use the bathroom or whatever is after Party City.
Okay.
So, Mr. Harwell, I mean, one of the other factors typically that we would consider in a premeditation analysis, maybe in the context of this case in particular, is whether there was any provocation by the victim on the front end. As I understand, at least in my review of the record, there didn't appear to be any provocation from the victim here. And if that's the case, is that a factor the jury could consider when considering the circumstances giving rise to premeditation? Or why wouldn't that apply?
I think, I mean, my general position on the bland factors, all of those are relevant things to think about. They're not exhaustive. They're not the only things to think about. There's no, if you have 3 bland factors, it's definite premeditation. I think it's really a sort of a common sense totality analysis.
Okay, and so with that, and there being maybe arguable evidence of calmness after the killing, maybe pretty clear evidence of a lack of provocation before the killing, it seems like you have at least a couple of factors in the totality of the circumstances when considering premeditation. And so how is it then, with your argument, that no reasonable jury could ever find the element of premeditation beyond a reasonable doubt?
Well, let me push back a little bit on provocation. To me, provocation has some different meanings. There certainly is an argument that there wasn't sort of provocation in the voluntary manslaughter sense of the technical definition of provocation was. I think there is evidence of provocation in the sense of this was not a completely calm interaction that suddenly he shot a gun afterwards, right? There was evidence that there was things going on that could contribute to him having an emotional reaction. He had left, I mean, and none of this is offered to make it defensible or to make him look good, right? He'd left his wife for this woman, setting up a new life for her. If the state's proof was to be believed, shortly after sort of giving up everything for her, now she's leaving. And is that legally sufficient provocation? That's not my issue. But is that something that could make someone angry, resentful enough to not be able to exercise judgment? I would think, of course.
So is the position ultimately then that while not voluntary manslaughter here, that at best it's a second-degree murder conviction?
I think that's right.
Okay.
Because they know what happened well before, they know what happened after, and in the middle, it is clear there is some kind of argument, whether it's a physical argument, just a verbal argument, what she says, what he says. There's something going on, but we don't know exactly what it is. In particular, because we don't know exactly what it is, we don't know exactly how upset, how clouded, how angry he is. I don't think anyone could read this transcript and say, I can say beyond a reasonable doubt that I know the state of mind that Roger England was in at the time he pulled the gun. And the problem is, getting back to having to prove a negative, to convict him of first-degree murder, you have to be able to say that. You have to be able to say his state of mind, beyond a reasonable doubt, was capable of cool reflection. He was not so clouded by anger and resentment that he could not exercise judgment. And that's the whole that it's, you know, as I say, it's not justification, it's not a defense. It's really hard to prove first-degree murder when you don't have eyewitnesses or a specific other evidence that directly reflects on the state of mind of the defendant at the time that the gun is pulled. So that's the essence of the sufficiency issue. Briefly, just to touch on the other issue of the admission of emails and audio and video of calls that were introduced through custodian at the detention facility. There was an appropriate and well-argued objection that this evidence was coming in, and the only takeaway that the jury would receive from this evidence was the fact that Mr. England had been held in pretrial detention. There's cases we have suggested that that is an infringement on the presumption of innocence. And what is interesting to me, and what I think is indicative of the problem here, is this evidence didn't actually further the state's case in any way, right? At this point, there's no dispute he pulled the trigger. The defense admitted that up front. The state had proven it over and over again. And there's no disputed issue that having Roger England say it's worse, it's manslaughter, or having him say it's not first, there's no disputed issue that helped the state's case in any way. If he were admitting to first-degree murder, yes, of course that would support the state's case. He's saying it's voluntary manslaughter. Yet the state wanted that in. The jury couldn't have considered that as proof of first-degree murder in any way, other than on the completely cumulative issue of was he the one who did it. But the state was being informed repeatedly that he's in custody, suggestive of some kind of decision by a trial court that a bond either needed to be denied because of having been granted and revoked, or that a judge felt the bond had to be set in an amount that was sufficiently high the defendant couldn't make it. And
so I think I understand from where the argument originates. I'm not as clear about what the logical limiting principle is. I think if you were to carry, that argument to its logical extent, you could never have testimony, for example, from a cellmate. Someone who comes in and says, yeah, you know, I was here and Tom Greenholtz told me this over here, and now I'm telling you, the jury, because that could only have arisen because defendant was in custody during the time, presumably had been denied a bond, or other just jail phone calls. So where's the limiting principle here with respect to not having the jury infer guilt from the fact of pretrial incarceration?
I think it's a 403 issue. Okay. That the prejudice is what is the jury going to infer about Mr. England based on the fact he's in custody. And the probative value, I suggest, is zero or very close to zero, because they were not proving anything that actually was helpful to their case as a probative matter. It was him admitting to involvement that was completely cumulative at that point. And so when you have a definite prejudicial effect but no probative value, I think it's very different than if you have a jail phone call in which someone who is trial defense
That there's
is,
some
I didn't do it,
probative value. Okay,
and
sure.
they're admitting to it at a trial. I will reserve the rest of my time for rebuttal.
Thank you. General?
Good morning, Your Honors. Abigail Renard for the state. I'll limit my discussion to the issues that Mr. Harwell just addressed. This court should affirm the defendant's conviction for first-degree premeditated murder. The defendant was married with children when he and the victim moved to Knoxville, and then after a night out, they got into a verbal altercation, and she decided to leave him. She began packing up her things, loaded her car, and even put her dog into the passenger seat of the car. Then, as she was carrying a load of clothes out to her car, the defendant pulled out a gun and shot her in the back of the head. After killing her, he was then calm and took steps to cover up what he'd done, and this evidence was sufficient for the jury to infer premeditation. Moreover, the court properly exercised its discretion when it admitted the defendant's relevant jail calls and communications. They included his own statements about the shooting, and there was no unfair prejudice in this case because he wore street clothes during the shooting at the trial, and any references to his pretrial incarceration were very minimal. So turning first to the evidence of premeditation, I think it's important first to note that the statute says that the defendant must be sufficiently free from excitement and passion so that he's capable of premeditation. The state here was not required to prove that he was not experiencing any amount of emotion, that he was not at all angry, just had to prove that he was sufficiently free from excitement and passion. And here there are multiple factors that demonstrate that. Going first to the defendant's calmness after the shooting, the timing here was somewhat unclear, but not entirely. The victim's last outgoing text message was sent at 12:39 in the morning. And there were two phone calls that the defendant made to Mr. Hoover. The first one was at 11:54, and then the second one was at 12:11. And both the defendant and Mr. Hoover said that it was the 12:11 phone call when he asked Mr. Hoover to come back and pick him up. Mr. Hoover thought that it took him around 25 to 30 minutes to get back to the house. So that would have put him there at right around 12:40, almost immediately after the victim's last outgoing text was sent. So Mr. Hoover gets to the house almost immediately after the defendant shoots the victim, and the defendant walks out of the house through the garage door carrying a case that appears to be the gun case and holding a beer. He gets in the truck, drinks his beer, smokes a cigarette, and just has a conversation with Mr. Hoover. He apologizes for cursing at him on the phone, and they had been friends since childhood, and Mr. Hoover did not see any reason to be concerned. He thought that perhaps Mr. England was just upset that he had gotten into a fight with his girlfriend. And it's not till much later in the drive, I think around 40 minutes, when Mr. England tries to call his wife, is told that he can't go back home to her. That is when he becomes upset and realizes the gravity of the situation that he's now in and starts becoming more erratic. And that emotional response later on does not diminish the importance of the fact that immediately after pulling the trigger, he is calm. And beyond that, there is no evidence of provocation here. The victim was trying to leave. She spoke with two people and told them that she was planning to leave. One of her childhood friends said that her voice was shaky and he'd never heard her sound that way. And so then she packed, loaded her car, put her dog in the passenger seat, and was walking out the door when she was shot in the back of the head. There's absolutely no evidence of provocation here. The defendant's admitted reason for shooting her was also that she was leaving and he didn't want her to leave. He said he did not describe this as, when he spoke to police officers, he did not describe any sort of physical altercation. I believe one of the officers actually asked him if it ever became physical, and he said, no, it was not that type of argument. This was a verbal altercation. I believe there was officer testimony that Mr. England never described anything that night as being sudden. Rather, he told them that she was leaving and he didn't want her to leave, so he shot her. That is certainly evidence of premeditation, and the jury could reasonably infer from all of this that he decided to kill her rather than allow her to leave. Also, there was some evidence that he retrieved a gun from somewhere in the house. just providing more evidence that he took steps. Before the shooting, he called Mr. Hoover to plan his exit route, and then he also took steps after the murder to cover it up. Again, while they were in the truck later in the drive, he started calling and texting the victim. He continued calling and texting her the next day. He returned to the house, and then continued just changing his story throughout all of his interactions with the medical personnel who first responded and also with the police. And this evidence was sufficient for the jury to infer premeditation.
How strong are the factors after the killing as reflecting on the element of premeditation? So I know this court has intimated, at least in some cases, that desire to cover up evidence of the crime or to escape justice may arise from the fact of having committed any crime. So if, as Mr. Harwell says, it was truly a second-degree murder, I would expect to see those kind of same actions afterwards. So in the context of this case, how did the efforts to cover up the crime reflect on the element of premeditation if we're looking at the exercise of reflection and judgment?
I think it's still relevant to the issue. I agree that it could also be indicative of second-degree murder, but here we're looking at the totality of the circumstances. So when considered with all of the other evidence that we've just talked about, it's still relevant to that he then, continued taking steps. Like he had the initial steps that he took immediately after the shooting, and then he kept trying to change his story and kept trying to cover it up. And while that could be indicative of a second-degree murder as well, I think it's also relevant to his premeditation that he, maybe it wasn't the best thought-out plan, but it doesn't have to be the best thought-out plan to be premeditation. And if the court has no additional questions about premeditation, I'll turn to the jail calls issue. And here the trial court properly exercised its discretion. The jail communications were relevant because they were the defendant's own statements about the shooting here. And to push back a little bit on that the state was trying to show that he was in jail, that is not what was going on here. The state actually offered to stipulate to the authenticity to avoid calling the jail custodian and just try to limit as much as possible any reference to the defendant's pretrial incarceration. But the defendant did not want to stipulate as their choice. And so this wasn't offered trying to show that the defendant was in pretrial incarceration.
Sure. I think your friend on the other side makes a more nuanced argument, perhaps. He says at least that in the context of jail phone calls, the prejudice is going to be there, and so it is maybe what it is. But in this case, it wasn't balanced against any probative value. That the probative value of the phone calls themselves didn't help aid the state's case in excess of what the other proof was in the case. And so therefore the jail phone calls had no probative value, or at least that's as I understand the argument. As to the probative value of the jail phone calls, what's the best response to that?
Yeah, so I think there was probative value here. It's the defendant's own admissions, so I think that's kind of inherently going to have some amount of probative value,
But it's his own admissions with respect to a voluntary manslaughter, though.
Correct. So with
no
respect
dispute
to, with respect to the shooting, and it also shows, it continues to show even much longer down the line how he continues changing his story. And one of the phone calls, he's talking with a woman, and it starts out with him saying something along the lines of, I never talk to Dustin about you. It's not clear who the woman is, but they're talking about Dustin and Mr. Hoover, and then it turns into kind of this conversation about whether or not Mr. Hoover had potentially hidden a gun. There's some evidence to suggest the trial court ultimately admitted this evidence because they thought it demonstrated consciousness of guilt and suggested that potentially Mr. England had given Mr. Hoover the gun to hide it away. And if you listen to the phone call, there's certainly some evidence where you could infer from that potentially Mr. Hoover had hidden a gun, or the defendant thought that he had hidden a gun and wanted this woman to help him find the gun and find out what happened to it so that they could get testing for it. And so
if it's offered for consciousness, and you'll forgive me, I interrupted you again, and I'm sorry for that. If it's offered for consciousness of guilt, though, here with respect to maybe hiding evidence or otherwise, Once again, how does that go back to premeditation? Because as I understand, at least the proof at the trial, there was no dispute as to the defendant shooting the victim. It seemed to me that, as I was looking at the record, there's no real dispute about that at all. And so consciousness of guilt in terms of a homicide may be one thing, but we're talking about really the grading of the homicide. And so merely to say that the evidence is relevant to consciousness of guilt is not to say then guilt of what. And so what was the trial court's reasoning here for allowing this evidence to show that the killing was an intentional killing and that it was done with premeditation?
I think it was more to simply allow the state, there's no real dispute that the defendant shot the victim, sure, but the state still does have to actually prove that and have to prove its case. So I think that was part of the reasoning, was allowing the state to prove its case. And here, whether it's probative of premeditation or not, it's probative of what the defendant was thinking later down the line, which is still relevant, and it's not unfairly prejudicial. Any reference here, it's a very small amount of testimony that the records custodian had, very minimal references to the pretrial incarceration. And in the actual communications themselves, like if you watch the video or listen to the call, it's not immediately apparent just based on the video and call that the defendant is in jail. So the references to pretrial incarceration are very minimal, and it's certainly not unfairly prejudicial. And the defendant was wearing street clothes throughout the trial, so it's not the same as having him, say, show up in handcuffs or jail clothing or anything of that nature. And the court also instructed the jury on the presumption of innocence, so there was ample things in the record to work against, the jury trying to infer that from pretrial incarceration and trying to find guilt from that. And also,
was there a limiting instruction? Was there a limiting instruction given at the time? Because I could see where a trial court would say, look, I'm going to allow the evidence, but I'm going to instruct the jury to infer nothing from the fact of incarceration.
I do not remember there being a limiting instruction.
Was one requested?
I don't believe so. Okay. Not that I remember, but I would rest on the record for that. And additionally, this is a first-degree murder case. I don't think any juror would necessarily be surprised to learn that in a case of this magnitude, the defendant was subject to pretrial incarceration. And this court has said similar things in cases. And if the court has no further questions, we would ask that you affirm. Thank you.
Thank you, Jenna. All right, Mr. Harwell, rebuttal.
I think I have 4 points. One, briefly on the calmness issue. The court will obviously review the transcript. I did note the state today was taking somewhat inconsistent positions in saying that during the drive, Mr. Hoover was just believed that Mr. England was upset because he had a fight with his girlfriend. And if that's the case, that is not the same as Mr. Hoover believing Mr. England was calm, whether or not he identified the source of the upset correctly. More significant point, I think, is, and this is maybe a point that Judge Greenholz, that you made better than I will, which is, to the extent we are focused on the question, as I've tried to frame it here, of at the time that Mr. England takes his gun and shoots Ms. Polk, is he sufficiently free from excitement and passion as to be able to exercise judgment? If that's the question, then I suggest what he does hours, days later really sheds no light on that question. I can be, well, I hate to say but I can be so angry and that I can't exercise proper judgment and do something. That doesn't mean that tomorrow I'm not going to be worried about being apprehended for it and try to do something to cover it up. Those are just unrelated things. The fact that I engage in a cover-up, unless it's a cover-up that is sort of shows I've been planning this for months, then maybe that would suggest I wasn't sort of in a state of passion. But so the kind of haphazard cover-up we have here, attempts to get rid of evidence, attempts to whatever he did, is not, in my mind, in any way inconsistent with him having been, at the time he pulled the gun, pulled the trigger, not capable of premeditation. Briefly, I want to talk about the the jail phone call, and all I can say, the one about the gun, all I can say is I encourage the court to listen to it, as I listened to it in the car again this morning before coming in here, because I've listened to it over and over again. It makes no sense to me. It is Mr. England talking with an unidentified woman about Mr. Hoover and about someone named Dustin, that I don't know who Dustin is. Dustin apparently has something to do with guns, and somebody has a new gun, and somebody got rid of an old gun, and maybe we need to find the old gun. It is a complete mystery to me. I think it would have been equally a complete mystery to the jury, other than driving home the point again that Mr. England is in jail. And the final point, and this is saying the same thing I've said a bunch of times before, the issue here, can you review this transcript, listen as a juror, have listened to all this evidence, and were you to be asked, was Mr. England so angry that he could not engage in reflection? Can you say affirmatively that he wasn't? I know that he wasn't so angry that he couldn't engage in reflection. And having reviewed this record, can you say, I know he wasn't so angry, and I have there's no reasonable doubt as to that. And I think where here there simply is this hole in the middle of the case, not from the state's fault, not because they presented it wrongly, just because first-degree murder is hard to prove. And when you don't have an eyewitness and you don't have a confession as to exactly what was going on in a defendant's state of mind, sometimes you will end up in a position like this where you can't prove beyond a reasonable doubt the negative that he was not clouded by excitement and passion. And otherwise, I'll rest on the briefs and ask for the court to enter judgment of acquittal on the charge of first-degree murder.
Thank you, Mr. Harwell. All right, that concludes the October docket. Court will be adjourned.
All rise. This court will stand adjourned until the